Welcome back. This is part 3. So, just going to dive into this. Again, real quick, if you guys have been enjoying this so far, or you find it useful, give it a thumbs up. Like the video, please. It helps with the algorithm. Also, subscribe and share it. Please manually share these, like cut and paste it to people on Facebook, whatever, wherever people are interested in learning this sort of material. Okay, so number 13. The case was dismissed due to an alleged lack of jurisdiction in the Intermediate Court of Appeals, and that is an entirely separate set of videos I can put together so that you all can see what I did for that process. 14. A hearing was held on January 4th, 2018, in which Deputy Prosecuting Attorney Christopher Schloiter entered insufficient oral charges for the first time on the record. I entered objections to the entry of charges by the prosecutor as the statute of limitations had expired months earlier. My repeated objections were ignored by Judge Freitas, and he entered a plea of not guilty. Here's the references, and again, I have like a slew of places where, the appeals court could reverse the lower decision, lower judgment against me. These official transcripts here, right here, actually show me entering my objections, and Judge Freitas just completely pretended as if I wasn't speaking. You can watch the video, it's up on YouTube. A motion to recuse Judge Freitas was filed on January 11th, 2018. Judge Freitas passed upon this recusal and denied it on January 18th, 2018. So anytime a judge behaves in a manner such as Freitas did at that hearing and at prior hearings, it's in your best interest to put together a motion to recuse them and lay out what reasons exist for trying to get them off of the case. They have to be reasonable. Try to eliminate any sort of emotional biases, because if you do something based on emotion, you're absolutely wasting your own time. And I honestly don't care if you clog up the courts. I don't. They're corrupt. Clog them up. But, it's your time. Don't waste it. Be efficient with your time. In this case, the fact that he just ignored my objections to the entry of charges past the statute of limitations, that alone was grounds to try to get him to recuse himself, because I'm supposed to be heard, right? What's the point of having me there if you're not going to listen to my objections? And it's not as if I was making some, insane sovereign citizen argument. They failed to meet their burden in the amount of time that they were allocated. That's on them. 16. A request for findings of facts and conclusions of law was filed on January 26, 2018. On February 1st, 2018, it was denied. 17. On August 16, 2018, I was put into a position of having to waive the right to speedy trial without ever having my request to know the deadline for holding the trial answered, as a result of a court clerk unlawfully creating two separate cases from one event, and my desire to have efficiency because of the wear and tear all of these appearances were having on my chronic health problems, which the court ADA was made aware of on December 5, 2016. I further requested that the date for the motion to suppress hearing be separated from the day of the trial as a result of having to sit on my terribly injured hamstrings for well past the medically documented limits. These injuries occurred on December 12th, 2003, and have altered my life permanently as a result. Judge Freitas refused to separate the days. Okay, that right there could be very well considered to be a violation of the Americans with Disabilities Act. You know, I don't know if they believe me, but my legs are a wreck. Like, you can see holes in the tendons in my left hamstring and my left adductor. It's a semitendinosus area. I'll have to put up MRIs of that at some point because it's crazy. Let's see, number 18, October 25th, 2018. A hearing on a motion to suppress evidence was held. The hearing was continued to December 7th, 2018 as a result of time constraints. On December 7, 2018, the motion to suppress was continued. Judge Freitas denied the motion after arguments were heard. Trial was set for January 18, 2019. On January 18, 2019, the state prosecutor requested a continuance because the witness, Officer Davies, was not available. I objected and requested that all matters be dismissed with prejudice. Judge Freitas denied my objection and granted the state a continuance to February 15, 2019. And they had already had continuances. If you have been watching this series of videos, and I think the first one, or no, the second one, I indicate where they got a continuance that the judge kind of masked and pretended it was the court's, issue. They weren't handling cases that day. All right, number 21, on February 15, 2019, a motion for a continuance as a result of being on medication and recovering from an anaphylactic reaction 2 days earlier. The motion was granted. The state motion to consolidate the cases for trial, the motion was granted. Trial date was set for March 1st, 2019. I already had info on record with the court regarding chronic health issues, but if you wind up having some sort of incident that prevents you from being prepared, it's good to have documentation if possible. I didn't have documentation that day, but I was a mess. I was a wreck from the 2 days before. It just felt like my brain was shut down. I couldn't hardly function. I don't think I put up a video of that, but you can hear I'm massively medicated in the video. I couldn't have handled anything at that point. Okay. March 1st, 2019, the trial began. Judge Freitas asked the state prosecutor, Linnea Downs, to arraign me. Oral charges were entered by the prosecutor. I objected on the grounds that the statute of limitations had expired for entering charges for violation of one count of driving a motor vehicle without a driver's license, HRS 286-102, and one count of no motor vehicle insurance policy, HRS 431 10C-104. I objected to Prosecutor Downs amending the charges that had been entered orally by Prosecutor Christopher Slater on January 4, 2018, also beyond the statute of limitations. I moved for a dismissal as a result of prosecution being time-barred from entering charges. Prosecutor Downs requested that the court take judicial notice of the citations written by Enforcement Police Officer Davies as being prosecutions initiated by complaint. Get a load of that. We'll get into that later. Judge Freitas denied my motion to dismiss, claiming that the Hawaii Rules of Penal Procedure Rule 7 had been fulfilled. I entered a not guilty plea under duress to all charges. Trial commenced. Testimony was entered by Officer Davies and state's witness Tricia Amalau. Cross-examination was had. State Exhibit 1 was entered into evidence. Defense exhibits B, C, D, E, F, J, K, M, N were entered into evidence. Trial was continued to April 12, 2019. On March 14, 2019, proof of service of Exhibit L to prosecution was filed with the court. On March, let's see, we'll just cut it right there. It's been 10 minutes. Okay, again, subscribe if this has been interesting so far, laying it out. I haven't really gotten into my arguments and the meat and potatoes yet, but this is basically setting the chessboard up for it. All right, stay tuned.